Yes.
And all the parties are in?
Yes.
This is just for recording.
Yep.
Good.
Oh, we're good, right?
Test 1 2 1 2 test.
court is honorable court are admonished regarding them with their attention as the court is now sitting. God save the United States and this honorable court.
Good morning, ladies and gentlemen. Our first case for argument this morning is the Boeing 737 MAX pilots litigation. Mr. Jones.
Thank you, Your Honor. Good morning. My name is Patrick Jones, and together with my colleague and co-counsel, Mr. Joseph Wheeler, we represent the plaintiff appellants in this case. Of my 20 minutes allotted, I'd like to reserve 2 minutes for rebuttal. The district court dismissed the plaintiff's claims of fraudulent concealment and fraudulent misrepresentation with prejudice. It held that the plaintiff could not prove that the damages suffered by the pilots was caused by Boeing's fraud. Second, the district court held that the plaintiffs failed to plead fraud with particularity. And third, the district court held that as a matter of law, there is no special relationship between Boeing and the Boeing certified pilots. I'll address each of these issues in turn, but first I'd like to address the basis on which the district court granted the motion to dismiss with prejudice and didn't allow an opportunity for the plaintiff to amend the complaint even before it had engaged in any discovery. This court may reverse a district court's decision to dismiss a complaint with prejudice if it finds that the district court did not provide a reasonable explanation for why it denied the plaintiff an opportunity to amend. In this case, the only explanation provided by the district court for dismissing this case with prejudice was that the plaintiff had filed too many, quote, versions of the complaint. That explanation was not only arbitrary, but it was also somewhat misleading. All but in this case, the plaintiff filed 4 versions of the complaint, but each one of them was either requested by the district court and was purely administrative, except for one, which amended the complaint to add account for fraudulent concealment and delete account for intentional infliction of emotional distress.
Mr. Jones, did you ever make an offer or proffer as to what you would have done in a 4th amended complaint?
Yes, Your Honor. As you may know, and as we put in our brief, since the case was filed, Boeing has admitted to certain fraudulent conduct to the Department of Justice.
Right, so after the deferred prosecution arrangement in the Justice Department and the SEC resolution, did you specifically identify those items as warranting a 4th amended complaint?
We did not file a motion to amend. We did, however, file a motion for the district court to take notice of the deferred prosecution agreement and provided them with authority, 7th Circuit authority to do so, and the court denied it. So the court was aware of the content of the deferred prosecution agreement and the admissions that Boeing had made. Were the plaintiffs allowed to amend the complaint in this case, to your point, Judge Scudder, the plaintiff would have amended the complaint to include Boeing's admission that the training materials and the flight manuals provided to the pilots, directly to the pilots by Boeing, were, quote, materially false, inaccurate, and incomplete. That's from paragraph 46 of the DPA.
The allegation is they were sent directly to the pilots, am I right?
That's correct. They were sent to the airlines who then gave them to the pilots. Yeah.
I see.
But the training materials and the FCOMs, the flight manuals, were actually protected, and Boeing actually asserted a copyright in those documents. So they were sent by Boeing, and they were Boeing's representations. No question about that.
To the airline, sent to the airline companies, not sent to a list of all known pilots. Or
That's
anything.
correct.
Okay.
That's correct. But Boeing obviously knew that they would be conveyed to the pilots. And the pilots actually had to review the training materials in order to get certified to fly the MAX. The plaintiffs also would have amended the complaint to include Boeing's admission that its fraud was the direct cause of their airline customers' monetary damages. That's from paragraph 12 of the DPA. We have also amended the complaint and will amend the complaint if granted, that Boeing's admission, to include Boeing's admission that the FAA relied on Boeing's fraud to certify the MAX with only a differences training requirement for pilots to get certified to fly the MAX. And that's a very low standard, which made it very enticing and very easy for pilots to transition from one type aircraft to another, to the MAX in this case. Finally, the plaintiffs will amend the complaint to allege that the fraudulent statements that Boeing made to the FAA and to its airline customers were substantially similar, if not identical, to the fraudulent statements that they made to the pilots. Therefore, because the reason given by the district court for dismissing the case with prejudice without an opportunity to amend was arbitrary and somewhat misleading, and because it would not have been futile to allow the plaintiffs to amend the complaint of issues that the court was aware of, this court should remand this case and allow it to proceed to discovery. Now to the specifics. Proximate cause, pleading with particularity, and the existence of a special relationship. Boeing's misrepresentations and half-truths made directly, as I stated, Judge Ripple, to the pilots were the legal, proximate, and but-for cause of the damages suffered by the pilots. In its opinion, the district court recognized that in a fraud case, as opposed to negligence, the causal link between the wrongdoer and damages is provided by the concept of reliance. And in this case, each of the plaintiffs clearly pled that had they known the whole truth about the MAX and the safety concerns that it posed, they would not have sought certification to fly the MAX, and they would not have continued to fly the MAX if that information was ever disclosed, as it was after the crashes. The court disregarded these allegations, however, and instead theorized that the plaintiffs had a timing problem. That is, the district court theorized that the plaintiffs couldn't have relied on Boeing's misrepresentations to commit to the training and the certification because by the time they could have learned of the whole truth about the MAX, they were already there.
Mr. Jones, I got a question about on the reliance prong in particular. In your reply brief, you can answer this when you come back up. I don't mean to give you a quiz on the spot here, but in your reply brief on page 15, right in the middle of the page, you have a series of citations to the third amended complaint that I think are what in your mind you were trying to point us to on the sufficiency of the pleading with respect to reliance. My question is, are those you know what you're putting stock in here? Are those the best citations? Because when I looked at each one of them, and when I tried to trace them through, the allegations of reliance seem quite thin to me. They seem conclusory, and they seem kind of categorical with respect to all pilots that way. So you can respond now or later.
Sure. I'll respond now as best I can, and then I'll take a look when I sit down. But the reliance in this case is sort of a negative because the pilots relied on Boeing's representations that the FCOM and the training materials were complete. So put yourself in the pilot's shoes, for example. You've got the computer-based training materials that Boeing created and sent to the pilots. That was basically a 20-slide PowerPoint presentation, followed by a short quiz. You're going through the PowerPoint presentation, reviewing the differences between the 737NG and the Boeing 737 MAX. And if those representations were complete, then you would have come across a slide that said something along the lines of, by the way, the MAX also contains a new system. We call it the MCAS. It's the Maneuvering Characteristics Augmentation System. And if we're being honest with you, we don't know how to handle a malfunction of the MCAS. If the MCAS malfunctions, you, your passengers, and your crew are all going to die. Now the court the district court said that that wasn't reliance because they had already committed to the training. This completely disregards the fact that the pilots alleged that if they had learned about that, they would have walked away. They could have just put down the iPad and gone back to their jobs flying other aircraft.
Yeah, what I guess the observation that was sticking out to me, and I may be mistaken, you can tell me I am, is that I would have thought you would have had a paragraph or a few paragraphs in that complaint, in the third amended complaint, that were specific as to pilots that said, look, make no mistake, there were two awful tragedies. 2 planes went down, everyone died. So I, as a pilot, was quite attuned to safety considerations regarding this particular plane, and I was paying close attention to what was coming out of Boeing, the manufacturer, with respect to this aircraft. So I was paying attention to the training manuals, I was paying, the training materials, I was paying attention to the flight manuals, and they didn't make any representations at all about the difficulties they were having, with the altitude system, for shorthand it that way. That's what I didn't see in the complaint.
Your Honor, I think the complaint repeatedly alleges that each of the pilots reviewed the training materials. They had to get certified to fly the MAX. And each of the pilots reviewed the FCOMs. They do that on a routine basis because that's basically the operating manual for the MAX. The complaint alleges that each one of them reviewed those materials and relied on the representations therein. And if the representation had been made by Boeing that the MAX contained the MCAS and that it could cause the plane to dive into the ground, they would have not flown the MAX. They would have walked away.
I find this a little surprising. The failure of any part or piece of software on a plane can cause it to fail. So in your view, as a matter of law, must the manufacturer state with respect to each part in the plane that if it fails, that failure can cause a crash?
No, Your Honor.
Then these manuals would be endlessly long.
They're
I
pretty
just
long.
bought a new car, and the safety manual is yay thick, all of which is filled with government warnings of that kind, making it completely useless, because no one can read it.
The pilots read these. They're required to. And the manuals don't say that if this malfunctions, it'll crash.
But that's what you say the manual should have said with respect to this system.
Right.
But everything else in a plane, that is also true of.
No, that's not correct, Your Honor.
If the ailerons fail, the plane will crash,
No.
and so on. Oh, yes, it will.
No, Your Honor.
That's perfectly straightforward.
The FCOMs are drafted to identify safety concerns and in case of a malfunction, what steps to take to combat
Yes,
that
and if the
concern.
engines fail, the plane will crash, and so on. What distinguishes this bit of software, other than the fact that this one turned out to have a flaw in it, from every other single point of failure in a plane?
What distinguishes it is that Boeing knew that this was a safety concern, and they also
It knows that the ailerons are a safety concern, and
Right.
the rudder, and so on.
And if those systems fail, there are instructions in the FCOM on how to compensate and correct those failures. But Boeing knew that there was no way to safely manage a malfunction of the MCAS. That's why they left it out of the FCOM.
I think you're just saying there are no other single point of failure problems in a plane, which I don't believe is true. Let me ask you a question along different lines. Your basic contention is that Boeing should not have shipped the 737 MAX until there was no risk of failure in the software. Suppose Boeing had done that and just deferred delivery. What would have been the effect on your clients?
They would have continued to fly the planes they were certified to fly.
And why couldn't they continue to do that when the 737 MAX was unavailable?
They-
That's the question I'm asking.
Right.
Right? Planes are often delayed. And the pilots presumably fly some other plane that they used to be certified to fly or that they recertify to fly.
Right.
Why is this any different from that?
You're absolutely right, Your Honor. The MAX should have been delayed.
I am not right about that or not. I'm identifying that as your principal observation. And I'm trying to figure out how your client's injury is different from what would have happened had the 737 MAX been delayed for 2 years. That, of course, is what did happen as a result of the grounding orders. But suppose Boeing had not delivered it at all, and your clients obviously couldn't fly it if it's not delivered. Right? How is your client's injury different in the non-delivery situation from the delivery followed by grounding situation?
Well, if Boeing had delayed the MAX until it was safe to operate, there would have been no injury. We wouldn't be here.
I mean, no one was trained to deliver the MAX until it had already been delivered? No, pilots are trained on planes before their delivery date so they can actually be flown when they're delivered.
To answer your question, if the MAX had been delayed, the pilots would have continued to operate the planes, the aircraft type that they were certified to operate. There would be no damages. We wouldn't be here.
Well,
but Boeing went forward.
I don't get it. Your premise of your complaint is that once they're certified to fly the MAX, they can't fly anything else, and so they can't fly. So I'm giving you a situation in which pilots train, get certified on the MAX, and Boeing doesn't deliver the MAX because it's working on the software. Do you have a suit?
No.
Why not? Why is that any different from delivery followed by grounding? That's the kind of question I'm asking.
Because the pilots would then still be certified to fly their own aircraft types. The certification expires after a time unless you renew it.
Well, so why couldn't they renew it?
They could have. They could have, and there would be no damages in this case if Boeing had delayed the delivery of the MAX until it was safe to operate.
But that's my problem. I don't understand. I understand why people who are on the doomed planes have a claim. But I don't understand why your client's claim is any different from what happens if Boeing delays the deliveries rather than delivering and then grounding a set of planes.
Because they admittedly committed fraud on the FAA, the airlines, and the pilots to get the MAX
I'm
certified.
asking about why your client's claim is any different. You tell me that in the delayed delivery situation, there is no claim. Then tell me in a simple way why delivering and then grounding is any different from delayed delivery.
For one, because they committed fraud. For two, because the MAX was in operation for 3 years before it was grounded. By that time, all the pilot certifications on other aircraft types had expired. That's the difference. If the MAX had just been delayed, they could have continued to fly under their existing certifications. That's the difference.
Mr. Jones, may I ask you a question about the types of fraud you've alleged in your complaint? As I understand, you've alleged both fraudulent misrepresentation and fraudulent concealment. Am I correct?
That's correct.
And with respect to the special fiduciary obligation that we find in Illinois law, does it apply to both of those claims or only to one?
There must be a special relationship in order to prove the elements of fraudulent concealment, not fraudulent misrepresentation.
Now, on the fraudulent misrepresentation, what difference is there in substance between that and your fraudulent concealment claims in this, according to the allegations in your complaint?
Right.
That trigger that difference in the elemental requirement.
Right. The elemental requirements are that fraudulent misrepresentation requires an affirmative representation, whereas the concealment is, in this case, they didn't provide any information about the MAX or how to manage it in the case of a malfunction. That's the concealment. And to have that, they have to have a duty to disclose, which is the special relationship which the plaintiffs adequately alleged in this case.
Why do you, This seems different, though, than the kind of fiduciary obligation that we usually see in the Illinois cases. Is this really a fiduciary obligation relationship?
I think it rises well above that. And that's a question of
Tell me why.
That's a question of mixed law and fact that the district court shouldn't have decided. But in this case, the plaintiffs alleged that they were in a position of weakness, dependence, and, quote, trust justifiably reposed on Boeing.
And where am I going to find that in your complaint?
I can give it to you on rebuttal, but it's pleaded ad nauseum throughout the complaint that the pilots were in no position to review and confirm or dispute the accuracy or the completeness of Boeing's representations made to them. They were completely in blind reliance and total reliance on Boeing for their safety.
Thanks.
And that's set forth in 2 versions of the FCOM and the training materials. I can see I'm out of time.
Thank you, counsel. I'll give you 2 minutes for rebuttal.
Thank you.
Mr. Primus.
Thank you, Your Honor. Craig Primus for the appellee, the Boeing Company, and may it please the court. The district court's order dismissing the case should be affirmed for the straightforward reason that plaintiff pilots have not and cannot plead the element of proximate cause. This pleading failure required dismissal of both the fraudulent concealment and the fraudulent misrepresentation counts, and those are the only 2 claims that plaintiffs appealed. Essentially, plaintiffs are asking the court to recognize a cause of action that would effectively be an insurance policy to replace lost income whenever a product is recalled or taken off the market and has a negative impact on workers that rely on that product. And that's an extraordinary proposition for which they cite no cases. They cite no case under Illinois law recognizing resembling a claim anything like this one. The complaint is clear, paragraphs 120 and 174, that plaintiffs' alleged economic harms flowed from the grounding of the MAX. But the grounding wasn't caused by statements made to the pilots in training. It was the end result of a chain of events that involved a lot of other actors and a lot of other decision makers, but not the pilots in this case. It starts with the design of the MAX, and then there were 2 crashes that involved other pilots, other airlines, and other passengers. And then the decision to ground the MAX, which was made by regulators around the world. And that in turn led airlines to make their own decisions to alter their schedules.
Stop.
Please. I'm okay. I'm all right. Thank you.
You need a new chair, Ken?
May the government may. Thank you. We think we have a coast roller on it.
You want a break?
No, I'm good.
Okay.
I'm good. Thank you. I'm sorry, counsel.
Certainly, Your Honor. Would you like a moment?
Obviously a shocking oral argument.
I was just taken back by your argument.
I've been
counsel.
doing this a long time. It's a first for me, and the power of the words. Sorry, Judge Ripple. I hope Your Honor is okay. Would you like to proceed? Thank you. The point I was making in somewhat dramatic fashion was that all of these decision makers made independent decisions that impacted the pilots, and they flow through this long chain of causation with lots of intervening causes and downstream effects. They don't seek damages under their own theory of the case for what they actually allege was the injury. Cases like this court's decision in Dundee Cement, Illinois Appellate Court decisions in Kraft Chemical and Philip Morris, which in turn cite a series of federal decisions, including this court's decisions and the Supreme Court decisions in Holmes and Associated General Contractors, they all stand for the proposition that there has to be a direct relation between the injury alleged and the harm alleged. And here, they cannot make that link as a matter of law. And I think Judge Easterbrook's questions hit on that point, the difference between delaying delivery and would they have a claim versus delivery and then a grounding. The pilots made decisions, the airlines made decisions as to whether to keep the schedule the same, and regulators made decisions as to whether to ground the airplane or not, and Boeing did not make those decisions. Those are all the steps in the chain that make it impossible for plaintiffs to plead or prove proximate cause. And Judge Easterbrook also hit on another point, which is that these pilots are certified to fly other aircraft. And the whole concept of the MAX was that it would be a plane that a 737 NG pilot could easily move between. So by definition, most of the pilots were already certified on the existing 737s. Whether the airlines changed their schedules in light of the grounding and whether the airlines staffed these particular pilots on different flight schedules that might have caused them to lose wages, that is not something that Boeing can or should be responsible for.
Mr. Primus, can I, just to get your introductory comments are helpful, I just want to get the benefit of you see where you differ with your colleague on the other side, and that is with respect to the import or lack thereof and what happened in the Justice Department proceedings and the SEC proceedings. Because as you know, Mr. Jones quite clearly features what happened there in a lot of his arguments, and in particular in the reply brief, he emphasizes what he sees as admissions that your client made to the Justice Department and to the SEC that are characterized as being quite direct to the pilot. So get the benefit of your reaction to that.
Yes, Your Honor. The deferred prosecution agreement does not contain any statements made to the pilots in this case. It involves statements made by two Boeing employees to an employee at the Aircraft Evaluation Group of the Federal Aviation Administration. The pilots don't appear in there. Statements that they allegedly relied on do not appear in the deferred prosecution agreement. It's just not about them. But more importantly, the point that the plaintiffs are trying to draw from the deferred prosecution agreement, which is that Boeing made misrepresentations, lied to the Federal Aviation Administration's Aircraft Evaluation Group, those are already in the complaint, which had to be assumed to be true. So adding the deferred prosecution agreement to go back and amend to add it will add nothing, because in paragraphs, there are at least 6 that I saw, 110, 126, 139, 140, 152, and 204, they all point to this exchange between Boeing employees and the Federal Aviation Administration. The most on point, I believe, are 139 and 140, which say that Boeing knew that disclosing what it knew about the MCAS and the inability for pilots to manage any malfunction to the FAA would prevent certification and prevent sales of the MAX. Then 140 says that to expedite the FAA certification and facilitate deliveries, Boeing made the deliberate and conscious decision to remove and conceal any information about the MCAS and pilots' inability to safely manage it in the case of a malfunction. So we have a situation where the deferred prosecution agreement, which Boeing stands by and can't contradict on the facts, on its terms, it doesn't speak to the plaintiffs in this particular case. And in all events, the plaintiffs have essentially paraphrased what occurred in the deferred prosecution agreement, so its addition would not have added anything. So those are 2 reasons why it wouldn't change the result and why the amendment should not have been allowed to provide for that. With regard to the question of the special relation, if I could move off of proximate cause, with regard to the other grounds for affirmance, I would just say that the proximate cause ground is the only ground that the court would need to affirm on. There are a lot of other issues that were raised and addressed below. I will just touch on them briefly. With regard to the fraudulent concealment claim, Judge Ripple, you asked some questions about the special relationship under Illinois law. This court said in Wygod, and it was relying on Illinois appellate decisions, that it is in the nature of or essentially the same as a fiduciary relationship. Boeing does not have that type of relationship with the pilots in this case. It doesn't have that relationship with its customers. All of them are very sophisticated arm's length parties that it deals with. Now, it deals with them truthfully, and it aims to deal with them truthfully, but it does not create a special relationship. And the plaintiff's theory would effectively take any complicated piece of machinery that is sold with instructions and to people who rely on those instructions, and would create special relationships, as Judge Seeger said, in almost every situation. So we don't believe that Illinois law, there's no case they've cited. In fact, I don't believe they cited any cases in their opening brief, but there's no case that they've cited that would even come close to approximating that. It's really left for fiduciary situations and really unusual dominant control situations like with the church or with the Boy Scouts cases. And then with regard to the fraudulent misrepresentation claim, if we were to go that far, the complaint, as Judge Scudder pointed out, is very vague on reliance and why these particular pilots did what they did in reaction to statements that the plane was safe. It's not the type of pleading that would normally survive 9B, but again, that gets into a lot of factual detail that I don't think the court needs to address if the court were to affirm on the basis of proximate cause. And then finally, I will just close by addressing the dismissal with prejudice.
Can I pause you on that?
Oh, yes, sir.
Yeah, one thing that, and Mr. Jones may want to speak to it a little bit too. In the discussion of the legal elements of the claim, the plaintiffs leave me with an impression of a bit of a merger between considerations of proximate causation and reliance. I've never thought of them as definitely not synonymous, but the relationship of them that the plaintiffs suggest seems confusing to me. I guess the question is, under Illinois law, they're two distinct elements, are they not?
They are absolutely two distinct elements. I think there might be confusion over cause and fact versus proximate causation, and you could see a position where a statement is made and relied upon in this cause and fact. But that is a wholly different question from proximate cause, which then goes a step further and looks for the direct relationship between the injurious conduct and the actual injury that's alleged. So completely distinct and separate. And the version that the plaintiffs advanced, I believe in their reply brief, would essentially read proximate cause out of Illinois law and would be inconsistent with the whole series of decisions that I mentioned at the outset. And then finally, just on dismissal with prejudice, I addressed, Judge Scudder, your question about whether the deferred prosecution agreement would have made a difference. It wouldn't have. And there were 4 complaints. They've been described as administrative, not substantive. That's actually not accurate. There were claims added, claims taken away. There were some factual allegations made throughout. They acknowledged the second amended complaint was substantive. There were changes made to the third amended complaint as well. So they had lots of opportunities and time to amend. And I would just also note that—
What was the timing of the resolutions with the Justice Department and the Securities and Exchange Commission vis-a-vis the third amended complaint, and just what was because, and the reason I ask this is Mr. Jones, is putting, I understand why, he's putting emphasis on statements in the deferred prosecution agreement that way. But did they come forward in the district court with the argument that, look, this really does change, our pleadings altogether here?
Your Honor, there were 20 months passed between the agreement and the deferred prosecution agreement and the entry of that and publication of that, and the time that Judge Seeger entered his order.
So after so the conclusion, therefore, would be, or Mr. Jones can that there was ample time after the company executed the deferred prosecution agreement to come forward with a fourth amended complaint, or at least seek leave to file, and to proffer how a new complaint would differ from the old complaints.
Yeah, that is our contention, Judge Scudder. We agree with that fully. The Judge Seeger, said in his order denying leave for judicial notice, he said, I'm going to look at the complaint. The claims will rise and fall based on what's in the complaint. At that point, it was entirely open to the plaintiffs to seek to leave to amend, to add those allegations to the complaint. They didn't do that. And then Judge Seeger, in management of his own docket, it took over a year for him to issue the order, and they could have done it at any time. I don't know whether he granted it. He would have granted it. That would be complete speculation. But they never asked, and in this court, they don't say how it would make any difference. So if there are no further questions, we'll rest.
I see none. Thank you, counsel.
Thank you, Your Honor.
Mr. Jones, anything further?
Yes, Your Honor. Counsel mentioned that with respect to proximate cause, there are many links in the chain. The fatal flaw in that argument, however, is that Boeing was responsible for every step in that chain. The district court listed 5 steps: that Boeing obtained the MAX certification by fraud on the FAA. That was Boeing's fault, no one else's. The 2 MAX planes crashed. That was Boeing's fault, no one else's. The entire fleet was grounded. That's Boeing's fault. And Finally, the loss of available flights. That's Boeing's fault again. Had they disclosed the MCAS, none of this would have happened. Boeing has admitted that in the DPA, Boeing admitted that the information that they provided to pilots, it's quoted in our brief, the information that they provided to pilots was materially false, incomplete, and misleading. That's to pilots.
Mr. Jones,
Final-
picking up on what I was asking Mr. Primus, when the company executed the deferred prosecution agreement, did you come forward in the district court and effectively say this is a quite material development? Because as as you're arguing here, you're arguing it very clearly, is that the company made admissions in the deferred prosecution agreement that are quite pertinent to the allegations that are in the third amended complaint. Did you come forward and say, look, we'd like leave to amend the complaint to amplify the allegations in light of the admissions?
We didn't, because they were those allegations were already in the complaint. They were just taken lightly by the district court. He dismissed a lot of the allegations as not well pled, or the plaintiff's mere say-so, or a heavy gloss.
Do you say that now, though, from the perspective, the benefit of hindsight, like looking back at the opinion that you ultimately received in the order, dismissing the third amended complaint? Because it seems to me that in real time, when you and your colleagues would have read the deferred prosecution agreement, you would have recognized what it is that you're arguing in your brief. In other words, that these are significant admissions in your view.
We believe they were, and we filed a motion for the court to take notice of those admissions, and the court denied it. We did not, as you say, move to amend.
I mean, taking notice is different than putting them within the four corners of the complaint.
That's correct, but the judge was aware of them and aware that if he approved the motion to dismiss, we could amend, and the amendment wouldn't be futile. But we did not before that, because we felt it was already well pled in the complaint. He disagreed, but nothing is more well pled than an admission. Finally.
Thank you, Mr. Jones.
Okay, thank you, Your Honor.
Case is taken under advisement. Our next case for argument is FC Bloxham Company against Tom Lang Company. Ms. Esquivel.
Good morning, Your Honors. May it please the Court. My name is Katie Esquivel, and I represent the appellant, FC Bloxham. Today we seek reversal and remand of the District Court's order adopting the findings of the United States Department of Agriculture in a contract dispute between 7 Seas and FC Bloxham. In appealing the decision of the USDA to the District Court, Bloxham was finally entitled to have the opportunity to conduct meaningful discovery on the single piece of evidence that the USDA relied upon in rendering its decision in favor of 7 Seas. That evidence specifically is what the USDA characterized as the unrebutted affidavit of Mr. Jason Lay, an employee of 7 Seas. That opportunity never occurred. The District Court here erred in 2 pivotal ways. First, it ignored the clear record of disputed material facts, making summary judgment both premature and misguided. Second, the District Court deprived Bloxham of thorough and rightful discovery. It did this in 3 ways. First, by failing to rule on Bloxham's pivotal second motion to compel, by ignoring Bloxham's 2 Rule 5060 motions, and by its inaction, the District Court condoned the deceitful and misleading tactics by both 7 Seas and Jason Lay that deprived Bloxham with a fair and adequate access to essential evidence. This case presents this court with a question of whether litigants are entitled to fair, relevant, and complete discovery before summary judgment is entered against them.
Can I ask you a question before you get too far on the
Certainly.
merit? how does appellate jurisdiction with respect to this court? I know that the statute talks about an appeal to the district court, but 499GC of the Perishable Agricultural Commodities Act says that the District Court of the United States for the district in which the party of complained of is located is the proper jurisdiction, right, for the appeal, as you will, to the district court. Why isn't the party complained of here Bloxam? And Bloxam is headquartered in Seattle, Washington, or at least has, that's its principal place of business or major place of business in the United States. So how does this end up in the Central District of Illinois? And are we confident we're in the right court?
Yes, Your Honor. And the reason for that is because 7Cs initiated the formal reparation action before the USDA. In response, Bloxam answered that complaint and also filed a counterclaim. And so Bloxam is appealing the loss on its counterclaim, and so the adverse party is in fact 7Cs, which is located in the Central District of Illinois.
Okay. All right.
So,
even if you're mistaken about that, it's not clear to me that that's a jurisdictional limitation as opposed to a, kind of a venue provision embedded within a jurisdictional provision.
understood.
Yeah. The reason I ask that is this is a statute that I've not seen before, and I know you've seen it a lot. Can you just spend maybe 1 minute on the legal framing here? If you all had to do it all over again, I wish you would both spend more time on that.
Certainly, Your Honor.
Because if you read the briefs here, I think you could be quite mistaken and think this looks like a breach of contract case. Looks like a diversity jurisdiction breach of contract case.
And it is. The Perishable Agricultural Commodities Act provides a host of remedies for produce sellers, and it also, a component of the statute also provides a dispute resolution process through the United States Department of Agriculture. It's intended to provide parties with a fast, simple forum to resolve disputes. And it first begins at an informal stage where there's an exchange of documents. The USDA renders an informal decision. Here, Bloxam prevailed at that stage. And if a party is unhappy with that outcome, it can then initiate what's called a formal proceeding.
Right, I follow all that until we get into the district court, and the argument is that there's basically an unfair practice or an unfair trade practice that occurred here. And
well, it's a little bit more than that, Your Honor, if I may. At the formal stage, the parties exchange written documents. There is no in-person hearing. There are no subpoenas. There is no discovery. The parties submit their own paperwork, and a hearing officer in Washington, D.C. adjudicates the dispute. And here, Bloxam was representing itself pro se. It won at the informal stage and felt that it was going into the formal stage in good hands. And Mr. Bloxam represented the company in a pro se manner. And so when the USDA finally issued its decision at the formal stage, the USDA said, well, there were 3 people who formed this contract. They were Bloxam's Brian Bernard, its former salesman, Alejandro Hernandez, and Mr. Jason Lay from 7Cs. And since Bloxam did not have any opportunity to conduct discovery with Mr. Hernandez, who had since left the company, or Mr. Lay, Bloxam made the choice to appeal that decision to the district court so that it would have the opportunity to conduct discovery and have a full factual finding and an actual trial on the merits, a trial de novo.
Yeah, I follow it.
Okay.
All right.
Does that answer Your Honor's question?
Kind of. Do we even know what law applies If it's a contract dispute, are we talking about Illinois law, California law, Washington law?
The USDA wasn't.
Does it not matter?
The USDA was not particularly clear, and for our purposes, it doesn't matter. The statute under 499GC, the statute says that the findings of fact of the USDA are prima facie evidence subject to de novo review, and that the appeal to the district court proceeds as in any other civil case. So the legal findings of the USDA have a significantly less importance than the factual findings. So here, the case presents the question to this court of whether or not litigants are entitled to a fair shot at discovery before summary judgment is entered against them. Here, although the USDA's decision relied exclusively on what the USDA characterized as the unrebutted affidavit of Mr. Jason Lay, Mr. Jason Lay's affidavit was for all practical purposes unrebutted. He was subpoenaed to appear for deposition. He attended his deposition for 173 minutes, including the argument of counsel, when he walked out, prematurely ending that deposition, and he was never compelled to return. This was not a technical oversight by the district court. This was a dereliction of the district court's duties to ensure fairness and to ensure that both parties had an opportunity to conduct discovery.
I don't read it as quite that harsh. I thought the district court said, especially in its alternative reasoning, I just don't see how it matters. Because in substance on, if I have the dates right, on August 13th of 2018, your client effectively had a full and fair opportunity to realize that the onions had not received certification and therefore could have stopped the shipment.
Well,
And nothing Mr. Lay would say or not say in the deposition would change that fact. In other words, your client knew on August 13th that it had not received either a copy of or evidence of the existence of the certificate. And nothing about Mr. Lay's not an employee of Bloxham, right? He's from 7 Seas.
that's correct.
Okay, so nothing he would say in a deposition would alter that fact. So that's what seemed to me, reading the district court opinion, was important to the district judge. So I think that's what you have to overcome.
Well, and my response to that is that the district court judge did not enforce the agreed order resolving Bloxham's first motion to compel. That order required both 7 Seas and Mr. Lay to produce evidence of Mr. Lay's communication.
Let me ask the question differently.
Okay.
Suppose you conducted a full deposition
Right.
of Mr. Lay.
Right.
What could he possibly say in the deposition that would alter the facts on the ground as of August 12th or 13th, 2018, vis-a-vis the certificate, the lack thereof?
Well, what the district court overlooked is the fact that Mr. Lay and 7 Seas was in exclusive control over the onions all the way. 7 Seas didn't just drop the onions off at the gate to the port. 7 Seas loaded them onto the ship, and in the meantime, 7 Seas was also affirming to Bloxham that the phytosanitary certificates existed. And there is course of dealing.
Before August 13th or 14th or after?
We believe both. But again, Your Honor, we did not have an opportunity for full discovery. We did not
I
receive.
don't understand what discovery could show that wasn't already in Bloxham's files. If Bloxham was told on a particular date that the certificate existed, Bloxham could show that from its own files.
Well, that was a presumption by the district court. However, the record is empty on that issue.
Well,
if the
but
court would like me
Bloxham
to
is the
explain it, I
plaintiff.
can.
Bloxham is the plaintiff. And if the record is empty, that means Bloxham has not disclosed the contents of its own files. Don't we have a problem for the plaintiff?
No, Your Honor, we don't, because Bloxham responded to the discovery requests that were propounded to it. In addition,
It's not a question of responding to discovery requests. Bloxham needs to show a particular fact in order to prevail. It has that fact or not in its own files and chooses not to show that fact to the district court.
that is what the district court found, but there's not evidence to support that. In fact, that presumes...
I don't even understand the concept. You don't have evidence to support what Bloxham told the district court, right? Bloxham either told the district court something or did not.
That's
You
correct.
don't prove that by separate evidence.
Right, and we can prove that by evidence that either comes from Bloxham and assumes that there was no IT problems, that there were any record-keeping problems on Bloxham's side, or we can obtain that from 7Cs. And in fact, 7Cs agreed to an order in January of 22 that it would provide those records to Bloxham.
I think we're talking about two different things here. You're talking in part about the purchase order. Okay. In my view, what I can't understand is on August 13th, 2018, Bloxham, and I think this is what Judge Easterbrook is suggesting, on that date, Bloxham knows whether it has evidence that the onions have been inspected and certified, or it knows it does not have that evidence. Focus on that date. Right, your client the answer to that question in your client's knowledge is either yes or no. On that date. That doesn't depend upon what Mr. Lay says or doesn't say in a deposition.
Oh, but it does, because it also doesn't include industry custom. Remember, we're dealing with
What
perishables.
Bloxham knows depends on what is in Bloxham's agents' files or heads, not on what Lay did. This is the message Judge Scudder and I are hoping to get you to address.
Because Bloxham's records are not the complete record of everything that transpired between these parties.
Did
That
Bloxham put into evidence the fact that there was, say, a fire or that its computers have been thrown out?
No, and we didn't have to, because the district court did not rule on order requests to simply enforce an order. There's two ways of showing communications, a sender and a recipient. Bloxham has been transparent about that since the day this case was filed. And I see I'm running into my rebuttal.
The word
time.
I would choose is truculent, not transparent. Your time has expired, counsel.
Thank you, Your Honor.
Mr. Amato.
Good morning. Just to address the subject matter jurisdiction point for a second, I think that the federal statute is clear that the federal courts have jurisdiction over disputes between buyers and sellers of fresh fruits and vegetables. Where venue lies is a different question. Where you can get jurisdiction over the defendant is a different question, but there is personal jurisdiction, but there is subject matter jurisdiction because this is a case involving fresh fruits and vegetables. My client, 7Cs, which is Tom Lang is doing business as, was a seller of onions, and therefore under PACA applies. My client could have proceeded one of two ways. It could have brought a district court proceeding over to collect the $24,000 owed for the onions. We could have commenced that district court proceeding in the first instance. In any jurisdiction, we could have gotten personal jurisdiction over Bloxham. Bloxham is resident in Washington State. We could have sued it there. But my client did not proceed under that path under the statute. There's an alternative path that my client could proceed, and that is to commence an informal proceeding before the Secretary of Agriculture, and then if that informal proceeding, which is in the nature of a mediation, is unsuccessful, it can then commence a formal proceeding, and we can have a hearing before the Secretary of Agriculture. That determination then can be appealed to the district court. So I believe that that's the answer to your question, Judge Scudder. On the question also that you raised as to what law applies, I think that the law here is Article 2 of the Uniform Commercial Code. This is a goods sold and delivered case. What are the terms of that contract? And that's what we needed to address here. Bloxham took the position.
Article 2 of the Uniform Commercial Code
Article
is just a proposal by the American Law Institute, right? It's either enacted into positive law or it isn't. Is there some state in which it was enacted into positive law on which you are relying?
I did address that in my brief, Your Honor. There are several states that would that have adopted this that are.
And there are several states that have modified some of the provisions in it.
Yes, Your Honor.
And Louisiana, which has never adopted it at all.
Right, but Louisiana wasn't involved in this matter.
Every other state
Florida,
seems to have been.
we have.
The only point, I don't want to get aside, the only point I'm trying to make is when I come to this case and I look at the briefs and we start talking about the Uniform Commercial Code, it's not a like a federal statute or something that's appended to this agricultural act, right? The only reason we'd be talking about the Uniform Commercial Code is because we're talking about the sale of goods.
Yes.
And that has to be relevant under one state or another state's law.
Yes.
And what I was trying to figure out is, what state are we even talking about?
We have several states here, and they all have adopted the same provisions.
all right.
So there is no conflict over what law applies. The transaction here happened with an oral call to 7C's office in Florida. Then there was the farmer was in California. The goods were delivered to Long Beach Port in California. Bloxham was located in Washington State, and Tom Lang was located in Illinois. As I pointed out in my appeal brief, all of those jurisdictions have adopted Article 2 and the provisions that we cited.
Adopted it in the same language?
The operative provisions that we cited in our brief, yes. Now to go back to the point here is that Bloxham, there was a very fulsome record before the Secretary of Agriculture. The Secretary of Agriculture just did not rely.
You do know what the meaning of fulsome is, don't you? It's basically, fulsome means obnoxiously long.
When I double-sided it, and I have it, Judge, it's this thick, double-sided. It's very long. For a $24,000 goods sold and delivered case that started with a simple phone call, there was an awful lot of papers that were submitted to the Secretary of Agriculture. So I consider, on a relative basis, that word definition applies here. Second, I think that we just didn't rely on the affidavit of Jason Lay. The allegation that was sworn to 3 times by Bill Bloxham, the Secretary-Treasurer of Bloxham, was that there were emails transmitting purchase orders to my client to the personal email account of Jason Lay, and those purchase orders set forth that my client was supposed to obtain phytosanitary certificates and fax them to Bloxham at the time of before loading and FedEx them to their Jetstream freight forwarders, who was their agent that was accepting the goods at the dock. Jason Lay said, I never received that email. I never received those purchase orders. That was the affidavit that was submitted. As it turned out, Bloxham admitted they did not send the purchase orders on August 8th of 2018. They proceeded in this case and got an extraordinary amount of discovery based on several sworn statements that there were emails to Jason Lay's AOL account with the purchase orders. It turned out, in opposition to our motion for summary judgment, that there were no such emails, that they never delivered the purchase orders prior to on or about August 8th of 2018. But it doesn't matter, because when we moved for summary judgment, we assumed, for argument's sake, that my client was obligated to obtain phytosanitary certificates and fax them to Bloxham at the time of loading and FedEx them to their freight forwarder. We therefore rendered irrelevant whether or not Jason Lay got or did not get these emails that they don't have a copy of and we didn't have, and we produced emails to show we didn't get them. it became irrelevant as to the discovery being sought because we assumed, for argument's sake, that the terms of this contract required my client to get the phytosanitary certificates and fax them to Bloxham at the time of loading. There is no material issue of fact that Bloxham did not have a fax. There is no material issue of fact that there was no FedEx. There's no material issue of fact that we didn't get the phytosanitary certificates. So now that you're a buyer, you are an exporter of record, you are delivering onions to Honduras, you are going to put 3 loads of onions on a container ship and send it to Honduras, and you don't have the necessary paperwork to import the goods into Honduras. Logic, forget Article 2 of the Uniform Commercial Code, Your Honor. Logic would say, as the exporter of record, who has to deliver a phytosanitary certificate in Honduras to get the goods imported, that you would stand on that provision of the contract and insist that you have the phytosanitary certificate by fax and FedEx. They did not. They should have rejected the goods. They should have, and if they didn't have the phytosanitary certificate, they could have accepted them under a reservation of rights. They could have obtained their own USDA inspection at the Port of Long Beach and put the goods on the ship. And finally, after they put the goods on the ship, there is no way for my client to cure this alleged defect. Under the law, that's a waiver of that condition under the sale contract. After the goods are on the water for 9 days, on August 23rd, the record shows that there was some sort of a communication on August 23rd asking for the phytosanitary certificates. It's too late by that point in time. On August 27th, there is an email that's in the record that says, where are the phytosanitary certificates? The goods wind up going to Honduras. After they're rejected in Honduras, there is a letter agreement that Bloxham signs where Bloxham does not even purport to revoke acceptance of the goods. The goods get returned to Florida for my client to then try to sell them for Bloxham's account. The goods come in, the onions are rotten, they have to be destroyed. This is a simple case. Bloxham, as the exporter of record, didn't do what a buyer, any reasonable buyer would do if they had this condition precedent, and that would have been to ask my client and have an unequivocal record before this court that they asked for assurances of some sort before they took the irrevocable act of putting the onions on the ship. They did not do so. We believe that the Secretary's decision was very well reasoned. We believe that the district court's decision was very well reasoned, and the district court did not terminate discovery proceedings. We moved in April of 2022. Bloxham had full knowledge of this argument that I just made to this court. Discovery continued into the end of July of 2022. Bloxham has had substantial opportunity in the district court as well as this court to answer the questions that I posed to this court as to why it didn't reject the goods. Bloxham still doesn't have an answer to that question. They continue to insist that somehow, some way, Mr. Lay, who's a salesman in a small office in Florida, who was accused of getting an email that he never got, and they admit that he didn't get, and they accused him of committing perjury and affidavits and wrongful conduct and the like, why Jason Lay hasn't been harassed by Bloxham. This is an outrageous situation. Now, I must say, Federal Rule of Evidence 1, I think it's the first one. We're supposed to have the rules interpreted for the just, speedy, and inexpensive resolution of every case. Rule 56 is a summary judgment provision. I think it was properly applied here. I think that there are no questions of fact, and unless the court has a question for me, I will rest.
Thank you, counsel.
Thank you.
Ms. Johannes.
Good morning, Your Honors. Vanessa Johannes on behalf of Appellee Jason Lay. I think the court has hit the nail on the head in asking whether any additional discovery from Jason Lay could possibly change the outcome as a matter of law that the district court opined on, and it cannot. There is no additional discovery from Mr. Lay that could possibly change this case and its track as a matter of law. Indeed, the PO orders, the purchase orders that the appellant Bloxham claims was sent to Mr. Lay they have in fact conceded was never sent to Mr. Lay. Nothing changes that it is the appellant's responsibility to have ensured the necessary paperwork was obtained prior to the sale of that vessel for the Onions, and nothing obtained for Mr. Lay could possibly alter the results. It is important to highlight the amount of discovery that Bloxham has received from Mr. Lay. They have received all of his work emails, all of his personal emails. His phones were imaged and extracted. They have received an immense amount of discovery for a salesman in Florida, when in fact, as Judge Easterbrook highlighted, if the email was sent, if the purchase orders were sent to Mr. Lay, then by sheer logic, Bloxham should have these emails. They should have the purchase orders. They have yet to produce any of those materials because now they concede they don't exist. That was the only reason they were afforded due process to get discovery from Mr. Lay, and discovery therefore should be halted, and the district court was correct in halting it. I also want to note for the record that Mr. Lay did sit for a deposition. He sat for 4 hours. That transcript is nearly 200 pages in length, and he was pro se the entire time. He was not afforded the right to counsel. He tried to seek counsel, and the appellant refused to allow him additional time to get counsel. Having a pro se witness, a lay person, be deposed for 4 hours, and during those 4 hours you don't ask a single question. Not once in that transcript is the word custom mentioned. Not once in that transcript is the word industry norm mentioned. Not once in that transcript is Alejandro Hernandez mentioned. Not once in that transcript is Brian Bernard mentioned. Yet here, that appears to be the discovery they seek. They got 4 hours with Mr. Lay, yet they didn't ask a single question about any of that. By law, the district court was correct in opining for 7Cs, and we ask that this court affirm their decision. If there are no further questions of me, on behalf of Mr. Lay, I rest.
Thank you, counsel. The case is taken under advisement. Our third case for argument this morning is Old Ben Coal Company against the Office of Workers' Compensation Programs. Mr. Pusateri, I call this case as Old Ben Coal against OWCP because that's how it's titled. But Old Ben Coal has not existed for 19 years, and litigation is supposed to be in the name of the real party in interest. So who do you represent?
Good morning, Judge Easterbrook, and thank you for that question. That very question is subject to a lot of controversy, and it is described in some detail in the response brief offered by my friend, Mr. Goldberg. That,
but who you represent is something you should know best.
Yes, Judge. We represent, among other folks, we represent Old Ben, and it's surety.
Old Ben doesn't exist.
It does not exist. We represent the surety that the Department of Labor has named as supposedly being responsible for this case. That is a surety bond that was issued and is now held by BP.
Could you try again, please?
That is a surety bond that was issued by a company that was ultimately acquired by BP. So that is who's paying my bills today. That is whom I represent. Whether that surety bond's validity is in effect and is enforceable by the Department of Labor is a question beyond the controversy this morning here, but it is a very fair question. But I'd like to focus instead, if I may, on
I don't think we can enter a judgment in this case until we know who the parties to the judgment are. I don't think something that has not existed for 19 years is an appropriate subject of relief in a court.
Well, thank
State
you.
law largely provides that corporations' existence can continue to wind up debts for a 5-year period. And you have not suggested that Old Ben was organized under state law that had a different length of time. I think you need to tell us formally and on the record who is on the hook for this judgment.
Yes, Judge. The answer is if if the Department of Labor's theory here is correct, it is a surety bond which remains in force, which was, after Horizon's bankruptcy, ultimately assigned to BP, and that is one of the parties we represent. That is one of the parties on our disclosure. And again, this is a fundamental principle of insurance law, that bankrupt parties' debts and responsibilities can nonetheless be discharged by contract through perpetual means or means subject to contracts, and that's what we have here, at least if the Department of Labor is to be believed here. But again, the APA here guaranteed Old Ben and its surety the right to a fair and full adversarial testing of the record proof. Old Ben did not get that. Instead, the ALJ's discretion was directed by a guidance document that was not subject to APA formalities, but is nonetheless proven to be impervious to challenge or debate.
Maybe I should put my observation differently. Within 7 days, I would like you to file a motion to substitute as the petitioner the entity that is actually financially responsible, because the alternative is to dismiss the petition on the ground that it was filed in the name of something that does not exist.
Yes, Judge.
I hope you get my point.
Understood, Judge Easterbrook. Thank you. The director's response to the petition before this court is frankly very frustrating to my clients. He focuses on a protective order that, if denied, would have prevented the reversible errors of law and fact we may be talking about later today. That protective order is frankly very unimportant to Old Ben's argument and to this court's job. He also focuses on training materials that offer one of but several reasons, 7 in fact, that we give for proving that the preamble's use here was binding and illegal. He doesn't even touch those other 6 reasons. And that's a big problem because it ignores completely at least 4 API violations that we've identified. And it's especially problematic.
Mr. Pusateri, as you get going and mindful of time here, we reviewing the ALJ's opinion.
Yes, Judge.
Are we kind of looking through the board's decision?
There is case law that says that this court's job is to review the ALJ's decision, not the board's decision.
And is that, in other contexts, that is true unless the board materially modifies or supplements or changes the ALJ's decision? Is that the way it works in this area?
Actually, no, Judge. I think under all circumstances, the ALJ's decision is what the court has to focus on and rely upon. And in this case, there are both questions of law and fact that
So
have to be
our
addressed.
focus should be on the ALJ, not the board in any way?
Yes, Judge, although I don't think the exercise is that different because, again, there are at least 4 APA violations, all of which the board implicitly...
Here's the reason why I think it might be different. That's why I understand the argument you're making about the ALJ's reliance on the preamble, and I'm sure you're going to get to that, okay? But I don't see the board doing a whole lot of discussion about the preamble.
I agree with that. I think the board...
So if we were to focus on the board, it would largely seem to knock your point out.
I disagree with that, Judge, because the board relied exclusively on the burden of proof here, which is substantial evidence. The board basically cited the ALJ's decision, shrugged its shoulders and said, good enough, that's supported by substantial evidence, but respectfully it's not. And it's not supported by substantial evidence because the ALJ's decision here, among many other things, including the Knudsen problem, which we can discuss if you'd like, though I think it's pretty cut and dry. What the ALJ did here is he cited a non-rule. He cited the preamble, and he gave it the force and effect of a rule, and it is not a rule. And not only that, he took the preamble and he cited it for things that it is wholly silent on. And not only that, he cited it for things that it is wholly silent on in a manner that preordained a result. And that is in fact the case here, because what happened in the case below is that this is a gentleman who had cigarette smoke-induced emphysema. The regulations don't even mention the concept of emphysema. The preamble talks about emphysema in a very general respect. It talks about the fact that some forms of emphysema can occur through similar mechanisms. And it cites a medical study called ROM for that proposition. But ROM does not endorse what the ALJ found here. In this case, we had 2 board-certified professors of pulmonology who cited medical evidence post-dating the preamble, including as recent as 2017 in the Kerriman decision, in the Kerriman paper. And they said, in this particular case, this gentleman's diffuse emphysema, which was confirmed radiographically and by his DLCO measurements and through the air trapping that the pulmonologists observed. This particular minor's particular form of emphysema was due solely to cigarette smoke.
And what expert are you relying upon? Dr. Rosenberg?
Dr. Rosenberg was the principal expert who talked about that, though Dr. Tudor did as well. But Dr. Rosenberg talked about that, and he gave a myriad of reasons, at least 4 different
And
reasons.
are you focused on his 2020 opinion?
I'm sorry, Dr. Rosenberg's latest opinion in this file was in 2016, I believe, EX7.
Okay, I thought there was a 20. I'm confused about that with Dr. Rosenberg. I thought Dr. Rosenberg gave 3 opinions: 2015, 2016, and 2020.
You might be right.
Okay, and what I'm trying to figure out is what's in the record. 2015 and 2016 seems to be in the record. 2020 does not seem to be. Are you relying upon 2020 for anything?
To the extent that it's not in the record, Judge, no, certainly not. Though we have opinions from.
Well, is it, or you're going to know better than I can't see that it's in the record, but I mean, you all litigated this.
Again, I believe Dr. Rosenberg did give 3 opinions. One was from 2015, one was from 2016.
Right, and the reason I'm not trying to be pedantic or give you a quiz or anything. In 2015 and 2016, he opined that Mr. McLean is completely disabled, totally disabled. But then in 2020, he reached a different conclusion. And you think, okay, well, hold on, that could be significant. He reached a different conclusion in 2020, but I can't tell if 2020 is in the record or not.
Judge, again, I believe what Dr. Rosenberg cited was the 2016 pulmonary function studies, which extrapolated for the gentleman's age revealed, and even when not extrapolated for the gentleman's age, revealed that he had no disabling pulmonary condition.
So as you're standing there right now, in your mind, you think 2016 is what you're relying upon?
Judge, I can revisit that issue in rebuttal when I have the record in front of me, but I think the answer is, Dr. Tudor also offered rationales that explained why this gentleman's specific form of emphysema was unrelated to coal dust. And that is, in fact, the key issue here, because the preamble was cited for things that it is wholly silent on. There's ample authority for that proposition, and in fact, I encourage this court to look at the cases where the preamble has been cited positively, because in none of those cases, Judge, was the preamble outcome determinative. It was not necessary to the resolution of those cases. My friend Mr. Goldberg references some of those cases in the opening statement of his brief at pages 8 and 9. And in fact, in each of those cases, it was the regulations themselves that were outcome determinative. The doctors who were discredited with incidental citations to the preamble in those cases rendered opinions that were inconsistent with the regulations, not the preamble. The regulations, of course, were subject to notice and comment rulemaking. The preamble was not. And those specifically dealt with citing clinical pneumoconiosis to rule out legal pneumoconiosis. Well, the regulations say you can't do that. They cited, there were opinions that said explicitly that legal pneumoconiosis is never latent and progressive. The regulations say otherwise. And so I urge the court to take a close look at those cases because, again, they do not stand for what happened below. They do not endorse what happened below. And again, we know that the preamble's use here was binding, Judge. We gave 7 different reasons for that, but I'd like to start with something very compelling. And that is in Young versus Bounty Mining, cited on pages 13 and 14 of our reply. The director himself urged a remand solely because the agency did not rely, the agency ALJ did not cite the preamble. And so what we see here is that not only does the director here not defend the preamble's use, but he is endorsing and vigorously, consistently, and successfully requiring its use in cases every single day. Young is but one example. The Shepard case, which we cited as Rule 28 authority, is another example. In that case, the preamble was used to nullify 3 opinions offered by board-certified pulmonologists with 130 combined years experience, And instead, the judge said, sorry, I find that to be inconsistent with the preamble, and I'm ruling in favor of the claimant. Those pulmonologists' opinions, by the way, like the opinions considered below, did in no way conflicted with the regulations, and frankly, in no way conflicted with the preamble. Again, when we're talking about different forms of emphysema, Dr. Rosenberg and Dr. Tudor explained that different forms of emphysema, cigarette smoking emphysema is a diffuse form of emphysema. This gentleman did not have diffuse emphysema, but the ALJ here said, I discredit his opinion because certain forms of emphysema are, the mechanisms of those are indistinguishable. And specifically, he cited the preamble, and he cited the preamble at pages 42 and 43, which cite the ROM study, which focused on focal emphysema. This gentleman did not have focal emphysema. And so what we have here is the preamble being cited for things it simply does not say, leading to wholly irrational analysis. And that type of analysis mattered to the Allentown MAC court. Allentown MAC cited 3 examples where they came to question the agency's decision-making and suggested that a policy was in fact being treated as a rule. And here we have all 3 of those. This gentleman, the ALJ, followed his own historical practice of citing the preamble wherever the question of the etiologies of cigarette smoking and coal dust-induced COPD were at issue. He offered wholly irrational analysis, as I described, by citing the preamble for things it is wholly silent on. He evinced a standardless approach, promising that we could archive the document, but finding that no proof, no matter how significant, could do that, and failing to explain what it might take to archive this document. And that's, I think, an especially important point here, because if adjudicators are the ones who are required to look at the medical evidence and say, well, to me, a smoking study is or isn't good enough, it isn't groundbreaking enough to challenge the preamble's conclusions, then what we're left here with is precisely what Judge Easterbrook thought was a problem in the Ziegler case, which is you have an agency that is relying upon things that simply don't have the statistical power to support their ultimate conclusions. And here we have more examples. Again, Young is an example of something that was absent in Allentown MAC, where we have the agency actually insisting upon its binding use. The judge below confused the preamble with the regulations, which themselves were subject to notice and comment rulemaking. And he justified that by the Miller case, which talked about legislative facts. Those training materials talk about the preamble as containing legislative facts. It does not. Legislative facts, by those definitions, are facts that are so uncertain, that are so beyond debate that they need not even be proven in a court of law. One of the legislative facts that the training material cites is the fact that emphysema and coal dust and cigarette smoking induced emphysema.
Thank you, counsel.
Well,
Mr. Goldberg.
Thank you. Yes, may it please the court, I'm representing the Director, Office of Workers' Compensation Programs. I'd like to clear up some matters first. The importance of the board decision here is that Old Ben, or whatever name you'd like to use for them, did not raise the protective order or the training slides as issues before them. The Black Lung Benefits Act.
Of course, if we completely ignore the board's decision, then presumably it's never necessary to exhaust any issue before the board.
Well,
do you agree with Mr. Pusateri that we just ignore the board?
No, because the regulations implementing the Black Lung Act have a regulatory issue exhaustion system. And this court has said that it will not consider issues that were not raised below. These were not raised before the board, they are forfeited.
So would you tell us why you disagree with Mr. Pusateri's contention that the court should pay attention to the ALJ and ignore the board?
Again, because the regulatory issue exhaustion system regime says—
I don't understand how that works if we ignore the board, right? It's like saying, suppose a regulation says before you can get judicial review of some decision, you have to write a letter to the editor of the New York Times, even though the New York Times is not in the decision tree. Regulation says that. Would we pay any attention to it?
in that
I think
situation.
the answer is no, right? So what is it? We're going to have to get this in order to figure out whether there's a real exhaustion requirement. What is the source of the disagreement between you and Mr. Pusateri about whose decision we are reviewing?
In general, yes, we agree that the court reviews the ALJ's decision. But there are also legal issues or legal holdings the board might make that the court...
Is there something that we should go and look at? Some statute, some regulation about this is a question about the relative authority of two entities within the Department of Labor. And that could be settled by statute or maybe by regulation. What do you want us to look at?
Well, I suggest first looking at your own decision in Freeman.
No, look, I asked for a statute or a regulation.
No, there is not a statute. The Black Lung Act or the implementing regulations do not address forfeiture as it concerns the Court of Appeals. This appellate court.
So the reason I raise this, and I think Judge Easterbrook's following, I can't figure, as best I can tell, the practice around the country, the custom in practice, is to review the ALJ's opinion. And then that causes me to wonder, what's the point of the board's review? Is it not entitled to any weight at all?
Well,
And it matters to me on this preamble issue. That's why I think we're not asking it just to, have an academic moot court.
of course. Well, again,
Are you directing focus on the ALJ, ignore the board? Is that what you're telling us?
no, I am not telling you to ignore the board because the forfeiture argument hinges on their failure to raise these arguments before the board.
See, now you're talking about forfeiture in a particular case. Judge Easterbrook is trying, what we're trying to get at is, across all these cases, should we focus on the ALJ's opinion or on the board's opinion or some combination, and what guides us?
Generally the board, but in some issues the board's holding should be reviewed by the court. And in this case, the fact that these two issues were not raised to the board.
I don't know why you're talking about this case. We're trying to get you to step outside of this case. I'm not talking about training slides or protective orders.
I understand. Generally, the court will review the ALJ's findings. The Fourth Circuit views it differently. I know we're not there. But
well, if we write an opinion, what should we do? And what's the source of what we should do? Just lawyers in the courtroom saying, do that?
Again, the source here would be the act and the regulations. You would review the
That's what I asked you to point to, and you aren't doing that. It's obvious that neither side is prepared to discuss this. We will give the parties 14 days after argument to file supplemental briefs addressing two questions. One is, who is the real party in interest? And two, whose decision is under review and why? And not in this case. This is a question about statutes and regulations. Okay?
Okay.
So here, can I just follow up, not with respect to the letter you all have to write, okay? What really throws me off about your brief is you say, very declaratively, the director takes no position on old Ben challenges to the weighing of the medical evidence.
Right.
So here's my question. Are you defending the ALJ's decision or are you not?
Regarding entitlement, we didn't take a position. We thought mistakenly that Mr. McLean's attorney would address that issue.
Yep.
That was our error. The other reason...
It's not your error. I do think we have some precedent saying that the director really does not have any interest in the personal interest of the claimant, who should show up and defend.
Right. Our interest is making sure the act is administered properly.
There have been questions in some of these cases why the director is even a proper party.
Yeah.
We're a statutory party.
I understand that, but that's not the same as saying a proper party to defend.
So the reason we're making this observation, of course, is because if you're not, maybe appropriately so, not taking a position on the evaluation and the weighing of evidence, it's a non-adversarial presentation.
Well, the other reason we didn't take an issue on the question of entitlement, because like you, we are unsure if Dr. Rosenberg's third opinion is in the record. To be clear, his second opinion in 2016, he did diagnose the minor as totally disabled. In the third opinion, he changed his mind, although oddly based on the same evidence as in his second opinion. The ALJ and
It just doesn't take it, because you're saying, yeah, I can't tell either. I
No,
mean, that
I
is somewhat comforting, because I can't tell. Okay, but you're not arguing against Mr. Pusateri on this,
No,
because you're not even challenging the weighing of the evidence.
No, because we don't know whether the ALJ reviewed all the evidence. For that reason, we think remand would be appropriate.
Is this the way that we don't get many of these? Is this the way this works around the country? That company counsel comes in, the Department of Labor comes in, and the department says we don't have any position at all on the facts or the weighing,
Well,
and then
sometimes,
there's nobody at the table that's going to challenge the other side. These are non-adversarial appeals.
sometimes we do take an issue. It depends on the facts. It depends on the ALJ's fact-finding or interpretations of law.
And certainly my experience has been in the large majority of these cases, the claimant files a brief.
Yes, generally the claimant does. We were unaware the claimant did not plan to.
It's kind of like a labor board case where there's the board, the union, and the employer.
We did want to correct one other point. Mr. Pusateri said that in Young and Shepherd, the director asked the board to force the ALJ to consider the preamble. That's inaccurate. In Young, we initially did, then we filed a surreply apologizing for the misstatements in our initial brief, and so that the issue was whether the doctor's opinions were in agreement with the regulations and not the preamble.
Mr. Goldberg, let's at least get the benefit of you being here and the expertise you have in this area. What's the proper use of the preamble?
It is not a rule. It is not mandatory. An ALJ has the discretion to ignore it completely. The ALJ has the discretion to consider it, and an ALJ has the discretion to find an opinion contrary to the preamble to be more credible if it's based on a proper scientific fact. But the post-preamble studies that Dr. Rosenberg relied on were found by the Fourth Circuit in Stollard not to address coal mine employment. They only addressed the effects of smoking. And this court has held that non-diffuse emphysema can be caused or contributed to by coal mine dust exposure. These are fact-specific cases, and the ALJ has great discretion in weighing the evidence, again, supported by substantial evidence. We wanted to address the, Mr. Pusateri's argument raised in his reply brief that arguing against forfeiture would have been futile, but this court has held that they must show that their claim, in order to come under the futility exception, the plaintiffs must show that it is certain that their claim will be denied on appeal, not merely that they doubt an appeal will result in a different decision. And when you see that they also argued before the board, in this case, that removal protections afforded to DOL ALJs deprive the ALJ of the constitutional authority, an issue they have never won on. It's hard to believe they would have had even less chance or equal chance there. We think the ALJ properly granted the protective order because they did not abuse his discretion. Ben was not substantially prejudiced because the preamble cannot address post-preamble medical studies. And the requested documents concern pre-decisional internal agency discussions. And this court has affirmed the use of the preamble for that matter in Consolidation Cole versus Director, 521 F 3rd 723 at 726. Finally, the training materials we think were largely irrelevant. Not only were they forfeited, but there's no indication that the ALJ based his decisions on those slides. The slides were not binding. There's no evidence the ALJ even saw or attended these, whatever training the slides were at. And the slides were not contrary to law. These slides say that in some cases, the source of emphysema can be based on the type, and that you can't rule out, and that ALJ should not credit a doctor who rules out legal pneumoconiosis based on negative x-rays, which comports with section 718-202. And finally, contrary to Old Ben's opening brief on page 34, the slides do not say, "Don't trust Dr. Rosenberg." Those words simply do not appear. Unless you have questions, I will return to my seat.
Thank you very much. The court directs both sides, your time has expired, Mr. Pusateri. The court directs both sides to file within 14 days supplemental memoranda addressing, first, who is the real party in interest, and second, which decision is under review and why. Once those memos have been received, the case will be taken under advisement. We'll hear argument next in the case of United States against Johnson.
Good morning,
Ms.
Your Honor.
Zarkulia.
May I please address the court? My name is Nina Zarkulia. I'm a court-appointed attorney for Christopher Johnson. Your Honors, we are here today because the defendant challenged the application note 3FI of Sentencing Commission and claimed that it's not enforceable under Kaiser versus Wilkie, the new Supreme Court case that we believe changed the landscape of our test, as well as...
Has any decision of the Supreme Court ever overruled Stinson?
No, Your Honor, and I'm getting to that right away.
So then what do we do about the Supreme Court's insistence that only it can overrule its own decisions?
Your Honor, we believe that indirectly it affected Stinson. And the reason why that's our position, and we understand there's split in the circuits, that some circuits have found that Kaiser affected Stinson, others believe that they did not overrule it, and one court at least decided not to decide currently on it. Our position is that if Kaiser affects our test and Stinson applies our test by word, then Kaiser affects Stinson. By that, I also want to point out that Stinson complained about...
The question is not whether Kaiser affects Stinson, but whether it overrules it. Has the Supreme Court ever said that it is proper for a court of appeals to depart from a decision of the Supreme Court that has not been expressly overruled? Ever?
I don't believe so, Your Honor.
In
I
fact,
don't believe so either.
Based upon my review of this, they've actually said the exact opposite. That is, it's only the Supreme Court that has the authority to overrule its precedents. I can think of two cases. I found two. There's probably a whole stack.
There's a stack.
But in Hone versus the United States in 1998, Justice Kennedy said this for a majority, and in State Oil versus Kahn the year before in 97, they said it affirmatively, that the lower federal courts are not to engage in tea leaf reading or the business of predictions, or however you want to characterize it. So I'm just not so sure we have any latitude at all other than to follow Stinson unless and until the U.S. Supreme Court says it's overruled or otherwise has been modified by what they announced. But that's their province, not ours.
Well, Your Honor, that certainly can be this court's position. However, we do believe it modified to some degree Stinson, because Stinson says that the commentary should be treated as agency's interpretation of its own legislative rules, and our test applies. Are we going to say that our test applies in one way for one department, in another way for another commission, and leave it modified for some but not modified for the others? And we do believe it's our position that Kaiser did affect Stinson, even though it's not directly addressing
I mean, the
Stinson.
premise of that is that the United States Sentencing Commission and an executive branch department or agency are exactly the same. That's
And-
not entirely clear to me.
It's not the same, and Stinson complained about it. But they said, despite the fact that the analogy is not complete, it's in that government is correct because the government argued in Stinson that the commentary be treated as the agency interpretation of its own legislative rules. And if we start with that, despite the complaint that commentary is treated as an agency interpretation of its own legislative rules, and the test that applies is our test, and then Kaiser goes and modifies that test, or at least cabins it, or at least gives it some outer bounds, then our argument is it did affect Stinson. That's what we start with. It's up to the court to decide at this point, and it might as well be that the remaining of the argument is not going to be useless at all if the court decides that Stinson is the law and Kaiser did not affect it or modify it. But should the court decide that possibly it modified it, then the question is, does this application note 3FI change? And is it enforceable under Kaiser and Wilkie? And this is the main crux of our argument. Kaiser and Wilkie—
Can I ask you something on the
Go ahead.
facts? I don't understand why both sides are talking about the concept of intended loss in this case. How does this case have anything to do with intended loss?
For two reasons, Your Honor. When the district court found the note 3FI enforceable, it also said that it would have passed the same sentence and found the same loss amount if it didn't rely on 3FI, simply relied on the application note 3A, which means choose between intended loss and actual loss, and then based on the having to estimate the loss amount, it would have relied on the intended
Yeah,
loss.
but it gets counterfactual. There's
what way?
there's no concept of intended loss in this fact pattern, right? I mean, Mr. Johnson is shown to have stolen 4,000 credit card numbers.
Correct.
Or 4,200, whatever the number is that way. And then the $500 amount, the kind of loss proxy, if you will, was used to estimate, to approximate actual loss. I don't understand what intent has anything to do with this. And I don't understand why. I'm asking you that because it doesn't seem necessary for this panel to resolve this case to say a word about intended loss.
And I agree with that, Your Honor. If this court says, for example, that the Kaiser affected Stinson and finds that 3FI is either enforceable or not under Kaiser, then it does not need to go in it. For example, should the court find that the 3FI is not enforceable? Now the question is, and this is the government's partly argument, is that, well, the decision should not be overturned because, well, the judge would have found the same thing under intended loss. That is basically what the government argues. We argue that should this court find that 3FI is not enforceable under Kaiser, it should go for resentencing because there is an actual loss amount there that should be recalculated. The government claims that intended loss comes in, therefore it should not be remanded for resentencing. That is my understanding because the district court judge did rely on intended loss as an alternative calculation to application note 3FI. If I may go back, Your Honor, briefly, we find that in the Kaiser test, the genuinely ambiguous prong, the court needs to find first whether the regulation is genuinely ambiguous when all tools of interpretation are employed, text, structure, history, and policy. And it is our position that any potential ambiguity in this regulation comes from the word loss, and that loss is not genuinely ambiguous word. The reason being is that when we look at text alone, ordinary meaning rules is that nobody would think of loss as something that hasn't been lost or that has an arbitrary minimum amount of $500. $1 is a loss. Even if it's a very small loss, it's still a loss. The government here tries to introduce the Black's Law Dictionary to claim that intended loss, for example, could be loss. I don't think Black's Law Dictionary should be a dictionary of ordinary meaning for a reason. But we do think that loss in everyday language does not have a bottom $500 limit. And as far as the structure itself of the text, is another thing of the regulation, another thing that we need to look at, I think there is a support here that anything under $500 is also loss. Government here wants to introduce relevant conduct guideline to explain that harm is the same as loss. I don't believe it is. They think that because harm all harm can come into a calculation of offense conduct and guideline range. Therefore, that guideline itself somehow affects the common 3FI, which we believe is not a sound argument because the guideline range for relevant conduct is a general guideline. It refers to all possible criminal conduct, including attempted robberies, and is much broader than loss in 2B1.1. Our second part of I will address history and purpose, Your Honor, just because this is where the government's argument is probably the most developed and the strongest. Legislative history, as far as the comments go, should not be a backdoor for some sort of creating additional ambiguity in the word that is otherwise unambiguous. Particularly because the comment section offers two different interpretations of the loss, as a measure of a seriousness of offense, and on the other hand, as pecuniary harm. Non-economic harm is excluded. Again, one narrower. When the legislative history is conflicting, Supreme Court was clear that structure and text rules. And finally, our second part of the argument is that should this court find that this word is genuinely ambiguous, that no less than 500 per card is not a reasonable interpretation of the word loss. And just because an amount is an average amount of loss per card, it does not automatically mean that it's a reasonable interpretation of the word loss. This would have to mean...
Thank you, counsel.
Oh, thank you.
Mr. Flanagan.
May it please the court. My name is Peter Flanagan. I represent the United States. Your Honors, the district court properly deferred to the guideline commentary when calculating loss under guideline section 2B1.1. First, the district court properly deferred to application note 3FI and its $500 per device rule. This court has repeatedly upheld the application of this commentary under Stinson.
Is this note among those that the commission is now in the process of moving into the text?
It is not. To my understanding, it is not. Judge.
Okay, thank you.
But despite the fact that the commission is not acting to move it into the text, this court has ruled on it under Stinson, has been addressed already today, and that precedent remains good law, even following the Kaiser decision. Second, even absent its deference to that special rule on loss, the court here was required to reasonably estimate the loss under application note 3C, and that included intended loss under application note 3A, and thus the district court reasonably looked to the well-supported $500 per card figure in calculating that estimate.
Estimate of actual loss, though. I just don't see what intended loss has anything to do with this fact pattern.
Your Honor, I'm not so sure of that because we are obviously operating first under the special rule of 3FI, which directs the $500 proxy for loss. But under this fact pattern, we are talking about thousands of credit cards that were purchased. Just as the nature of this scheme is that the defendants, there's 22 in this case.
Yeah, and I understand you can't trace all. I totally get that. You're not going to be able to trace it all out and get down to the last dollar of an actual, precise loss measurement. So you're approximating. You're doing an estimate under a preponderance standard. But you have a defendant here that's admitted to the theft, right?
Admitted to the theft and purchase and the use or attempted use of those cards.
Right. So you're using the 500 to estimate actual losses.
I'd be speaking against my own interest because I understand that it'd be much easier for me to just say yes, but I do think the fact that this defendant.
Yeah. In other words, if the authorities had rolled in after. He stole the 4,200 devices, stole them all, and they rolled in and arrested him, then you might have an intended loss situation.
Well, in this situation, there may well have been instances where the defendant obtained the cards, but they were canceled. or expired and were not usable by the time the defendant got around to using them. So in those instances, no actual losses would have been accrued on the card. And for that reason, we'd be relying on the concept of intended loss in that case. So I think that the $500 special rule is best viewed, as Your Honor referred to it, as a proxy for loss. But I would say it would wrap in intended loss as well as actual.
So what's the government's position on the Kaiser-Stinson issue?
Well, it is absolutely that Stinson is still good law. The Kaiser decision said that Stinson, which is obviously reached by analogy through Auer and Seminole Rock, and the Kaiser said that Auer and Seminole Rock are still good law. That was made explicitly clear.
Is that what the Solicitor General is telling the Supreme Court? Yeah, I have the same question as Judge Scudder, because the first of these cases that I saw, United States against White, which was argued back in January, the prosecutor took the position that Kaiser had overruled Stinson, arguing for the United States. And we asked, can this really be your position? And the prosecutor said, oh, well, it's my position, right? Leading to the question, who speaks for the United States, or does every assistant U.S. attorney just make it up on the spot? Usually we would think the Solicitor General speaks for the United States. So what has the Solicitor General been telling the Supreme Court when these cases, and they're being decided all over the country, when somebody files a cert petition?
The department's position is that Kaiser informs Stinson. Stinson remains good law. Kaiser does have an effect on the analysis. In this sense, it clarifies, it complements Stinson. Where Stinson states that the commentary is valid so long as it's not inconsistent with the provision itself, Kaiser tells the courts and parties how to determine whether that inconsistency exists. Kaiser does so, it focuses on whether or not there's an ambiguity in the guidelines text, and where the ambiguity exists, and so long as the commentary resolves it reasonably, by definition, the guideline.
Yeah, this is where it gets a little tricky, because you all, I mean, this is my perception, I might be wrong. I mean, you're doing a bunch of gymnastics in the red brief. When you say loss is ambiguous, I think, really? How is it possibly ambiguous? It's one of the most common terms known in law. There may be hard applications of it, or some questions that arise at the fringes, but the United States' position is that the term loss is ambiguous?
It is, Judge, and I think what this court directs that we look to the ordinary meaning of an
And that seems to me like you're taking that position because you're trying to force fit it into a Kaiser analytical framework.
Well, the department's position is absolutely, I do answer to others, we do take the position that Kaiser applies, Stinson remains good law, but Kaiser does affect the analysis of our guidelines commentary as it relates to.
I'm sure the Solicitor General calls it a sophisticated position, whereas others might be inclined to call it wishy-washy.
I wouldn't call it, I don't consider it wishy-washy. Certainly, speaking for the government, we don't consider it wishy-washy. We are aware, and the government cited two of them in its 28J letter recently. Courts have found that there's Stinson on one side and Kaiser's got nothing to do with it.
We certainly know that.
If Stinson applies, I don't know why you just don't say, go read note 3F1, the case is over.
Well, we do.
It's over. The district court did a simple math exercise, multiplied 500 by the number of the credit cards, and the case is over.
It is because the department's position is that Kaiser has informed Stinson.
Well, if Kaiser does inform or throw a crosslight, whatever you want to call it, on Stinson, do you still win?
Oh, absolutely, Judge.
Why?
The reason why, and this dovetails back into what Judge Scudder was asking, why would we consider loss ambiguous? There's two questions really at issue in answering your Judge Ripple's question. Is it ambiguous, and does the commentary reasonably interpret into the provision at issue? As to it being ambiguous, first this court directs that we look to the ordinary meaning of the term when it's undefined. And here, and dictionaries are a source of information for determining ordinary meaning. There are many different definitions, a whole range of meanings that you find in dictionaries. But I think more importantly is it comes from Kaiser itself when assessing whether there's an ambiguity. Kaiser provided a test to look to the structure, the history, and the purpose of the provision at issue. Here, history and purpose, well, the background of the commentary provides that it includes both, we're going to try and hold the fraud defendant responsible for the seriousness of this offense as measured by both actual and intended loss. Then if you consider the structure, the relevant conduct guideline, 1B 1.3 A3, and that's text. That's text of the guideline. That's something that I don't think anyone in here could say that any party could ignore. The structure, that provision says that we look not just to actual harms or the harms that resulted, but also harms that were the object of the conduct. In other words, intended loss. So when you bake all that in, loss is actually a more loaded term, I think, than you might think at first blush. When you have to account for all these different factors, and even once you get to the point where you say, okay, 1B 1.3 A3 applies, so we're left with a term loss that at a bare minimum includes actual and intended loss. Then you still have more questions about what is limited, what kinds of laws should apply in certain kinds of cases, and that's why we think that Kaiser, this particular commentary survives Kaiser and Stinson, which remain good law. See, my time is up. If unless there are any further questions for me, which I'm obviously happy to answer, we respectfully ask you to affirm the defendant's conviction and sentence.
Thank you. Ms. Zarkoui, we appreciate your willingness to accept the appointment in this case and your assistance to the court as well as your client. The case is taken under advisement. We'll hear argument now in the case of Singh against Garland. Mr. Moore.
Good morning, honorable judges. Thank you, Judge Easterbrook. Judge Scudder, we meet here for the first time. Welcome to this bench. Judge Ripple, I hope everything is okay. My name is Godfrey Mwange, and I represent Mr. Singh. And right out of the blocks, I'm going to concede something, which is in the respondent's brief, and that is that my client has an administrative exhaustion problem. However, I hasten to say that there are exceptions to that rule. And one of those has to do with the agency reaching an issue sua sponte. In this case, the board discussed past persecution and also discussed the IJ's analysis of the CAT claim. Now, the other issues that the respondents argued that we forfeited include the ineffective assistance of counsel claim. Now, part of why that does not appear very prominently in our brief is because I was afraid to hurt someone that I care a lot about but was already dead, and that is the lawyer who represented Mr. Singh at the board. Now, the reason that I think he should have done something more is because the lawyer who represented Mr. Singh before the IJ clearly performed deficiently, and I highlight that very slightly in our brief. Now, I feared hurting someone who was already dead. No excuse for that. But this morning, looking at Model Rule 3.3, specifically subsection C, I have an obligation to be candid when I'm standing here before you as a court, as a tribunal. And I have to tell you that Attorney Donamani in front of the IJ did things that I think the board was aware of, because when Mr. Block filed his notice of appeal, he attached an addendum which appears in the record at page 68, in which he said several things. He said, we don't have the documents. Mr. Donamani has not given us the documents, but also added that he filed documents that Mr. Singh had not seen and did not know what those documents included. Then he filed a motion to extend time to file the brief, principally because he still didn't have the documents from Mr. Singh's immigration court counsel. He attached an affidavit in which Mr. Singh swears a number of things. He swears, which is stark, that Mr. Donamani actually told him just before the hearing, if they ask you who attacked you, say BJP, not Congress Party. Now, that's problematic because Mr. Singh's story, until Mr. Donamani became involved in the case, and you see that in a document the IJ did not admit as evidence, but which featured prominently during cross-examination in front of the IJ, Mr. Singh says Congress Party 4 times, pages in the administrative record 179, 180, 189. Not once in that document at pages 176 to 183 does he even mention BJP. BJP comes up for the first time in a document dated August 20, 2019, which is in the administrative record at page 448 to 450, which is the first statement which Mr. Donamani withdrew. Now, after that, in documents that appear in the record under a filing made on February 21st of 2020, there are several documents that identify BJP as the attackers, and none says Congress Party. I don't believe that's a coincidence, because consistently prior to Mr. Donamani becoming involved in the case, Mr. Singh says Congress Party. But also in his affidavit he says, he told me, say BJP, don't say Congress Party. And so, is that something that the board should have addressed on its own? Well, its reviews de novo. But also, he notified it a couple of ways. First, in the notice of appeal addendum, then in his motion to extend time to file a brief. So that's in the record. And so if you look at pages 50 to 54, you see the motion to extend and the affidavit in which Mr. Singh says he sent documents to India that I hadn't seen, filed them without showing them to me. He prepared a statement he said was better than the first statement. He didn't discuss it with me. And so, to me, Mr. Block should have done something with that. Now, I know why, because I knew him very well. The brief he filed is dated it was filed July 8, dated July 7. That was after the July 4th weekend, and I'd seen him. He was in bed. He was working, though, with his laptop, but he was very sick. Is that contributory to what happened here? I don't know. I think it is. Now, the board itself, when it came to its review, said clear error is our review of the IJ's CAT claim. But when you think about a CAT claim and the IJ's analysis of it, the IJ is applying law to fact. And the law is in section 1208 A4 of Title 8 of the Code of Federal Regulations, where it includes mental pain in the definition of torture. Now, Mr. Singh has witnesses whose affidavits are in the record who say that those who attacked him went with the police to his mom's house and said, if we find him, we'll kill him. Now, if someone says to me that, guess what? They said if they find you, they'll kill you, I am going to suffer mental pain.
Mr. Mohanji, let me ask you a question here. In our court, you present the argument, primarily the arguments you're focused on this morning, within the framework of a due process violation, what you call a due process violation in your brief. Did you advance these contentions, because the IJ hearing, of course, already happened? Did you advance these in the name of due process before the board?
No, I did not, Your Honor, and I didn't represent Mr. Singh before the board.
Okay, did Mr. Right. Were they presented that way?
Mr. Block did not. Did not present them.
Yeah,
Were they presented as violations of any statute or regulation by the immigration judge?
They were not presented that way either.
Okay, so is this fit into the and I appreciate your candor at the outset of the argument. Does this fit into the category of these just weren't raised, but they're now being raised in the Seventh Circuit?
That is correct, Judge, and the respondents are correct that we are raising them for the first time here. Okay. And again, you know, human nature as it is, I was afraid. Now, as to the IJ's decision, I mean, the IJ says several things. The IJ says there are inconsistencies here, but the IJ says there are inconsistencies here in the oral decision, which happened after taking of testimony and evidence was closed. She says he did not explain them, but nobody confronted him with those inconsistencies to let him explain them. And she makes some other findings. For example, he doesn't belong to Shiromani Akali Dao Amritsar Party. Well, his testimony, which is unimpeached, is he joined that party January 1st of 2017. He says he is unfamiliar with the other goals of that party. Well, he's familiar with the fact that it helps the poor, that the government doesn't help. And he says that's exactly why he joined that party, worked for it. The IJ says...
Yeah, thank you, counsel. Mr. Privy.
May it please the court, Christopher Privy for the Attorney General. Counsel for the petitioner has conceded that most of his arguments were not presented to the board, whether it was by him or the previous attorney.
I think you're starting at the right place for your side here. Can you summarize what issues do you believe are before us on appeal?
That are properly exhausted and not waived.
Right. So what do you believe that we need to decide?
Whether one issue is whether the arguments are properly exhausted, and counsel has conceded that they are not. The only two arguments that I could find that did not need exhaustion, which are only just are arguments that the board did something wrong on its own, or that the board improperly compared the petitioner's physical injuries to those in Chutchman, and that's on his opening brief, pages 21 to 22, and that the board's holding of the waiver of the CAT claim was negated by its ruling on the merits in the alternative, and that's on opening brief, page 22. As to, if you would like me to address the merits of those two particular arguments, that the Chutchman itself says that it did this analysis where it measured the severity of the argument or the injury sustained by the petitioner in that case against cases that this court cited as having worse injuries, and still found that because those injuries had been not considered to the level of persecution or torture. Likewise for those in Chutchman. So Chutchman, it supports that there's substantial evidence for the agency's findings here. And then as for whether the board revived the CAT claim to some extent, the only thing that the board talked about was whether the police threat to arrest petitioner for reporting BJP attacks rose to the level of torture, and it did not. And under the Chenery Doctrine, that's the only reason that was given, and this court is limited to that reasoning. And does not compel a reasonable adjudicator to find that petitioner is more likely than not to be tortured just because a police officer threatened to have him arrested. Petitioner counsel made a couple more arguments that the government has not had a chance to respond to. I'll briefly respond to those. First is that talking in the argument just now about torture including mental pain, I do not believe this was argued in petitioner's opening brief. I've only been able to review it very briefly during his argument, but I don't think it was preserved in the opening brief, so it should be held waived by this court. And the second is in the reply brief, petitioner states that the Bosidi case is an exception to this court's exhaustion rule. Bosidi does not apply here. That involves a fundamental miscarriage of justice, such as ignoring this court's precedent and saying you can bribe your way out of persecution. That's not what happened here. In Bosidi, the IJ ignored evidence that the petitioner there proffered, and here, in this case, the IJ is accused of violating due process by accepting the evidence that the petitioner offered into evidence. And in fact, if counsel has if your honors have no further questions, then the government would respectfully request that you deny the petition for review. Thank you.
Thank you very much, counsel. The case is taken under advisement, and the court will take a brief recess before calling the sixth case.
is supported by the Illinois Supreme Court in its characterization in EMC versus Kemp. A judgment for foreclosure is final as to the matter it adjudicates. But even, Your Honors, even if judgments for foreclosure and sale in Illinois cannot be characterized as final, Rooker-Feldman applies to interlocutory orders under this court's precedent. For example, in Bauer, this court went on to explain that even if a complaint of order were not final for Rooker-Feldman purposes, as this court stated even earlier in the Harold versus Steele case, nothing in the Supreme Court's decision suggests that state court decisions too provisional for review in the state's own system can be reviewed by federal district and appellate courts. Additionally, in Sykes, this court stated, "We have held that interlocutory orders entered prior to the final disposition of a state court lawsuit are not immune from the jurisdiction stripping powers of Rooker-Feldman. As concluded by the Harold versus Steele case, a truly interlocutory decision should not be subject to review in any court." This comports with the premise, the rationale behind Rooker-Feldman that only the United States Supreme Court can review state court orders. Both of the judgments for foreclosure in this case were entered before this federal lawsuit was filed. And I need to correct counsel. She stated that while the Grand case has concluded, the 951 property case is still pending. That's not accurate, Your Honors. The order confirming sale in Grand was entered on March 16th of 2022. The order confirming sale in the 951 property case was entered on August 11th of 2023. There have been now 2 post-judgment motions. One was denied on September 19th, and another one has been filed, and I believe it's due to be heard early next month. But there is an order confirming sale. Additionally, Your Honors, these federal claims allege injuries from the state court judgments. The recent Hadzi-Tanovic case directly applies here, where you had a federal lawsuit alleging a conspiracy to deprive the federal plaintiff of familial associations, corruption in the divorce proceedings, and ex parte communications, as is alleged here. This court stated that the only way to determine to assess the claims of the federal plaintiff would be to assess the state court's handling of the case from top to bottom, procedurally and substantively, to determine if there were no errors or benign errors or evidence of corruption. But Rooker-Feldman bars this type of review. And additionally, in Bauer, the claims were much the same as far as conspiracy to introduce forged evidence, and this court held that Rooker-Feldman barred those claims. It's the same here. The conspiracy counts allege that a conspiracy was undertaken to deprive the plaintiffs of their property in order to foreclose. They state that in their complaint, and on appeal they echo this. They state that the improper communications resulted in the substantive relief in the foreclosure cases, and that the alleged conspiracy was to deprive the plaintiffs of their properties. In fact, they characterized their damages as resulting from the conspiracy to defraud the plaintiffs of their rights. But as this court pointed out in the Hadzi case, Rooker-Feldman looks not towards rights but to injuries. In this case, all the injuries are uniformly characterized as stemming from the foreclosure procedure and the orders. Regarding the slander of title and quiet title counts in the federal complaint, the plaintiffs similarly state that the defendants had no interest in the property and no legal right to foreclose. Indeed, these are direct attacks on the state court judgments, which found otherwise. Finally, Your Honors, the plaintiffs had an opportunity to raise these claims in state court. They actually raised standing in the Grand case. They could have brought motions to reconsider in either case during the period of time between judgment and the order confirming sale, and they could have appealed either case. And as this court pointed out in the Hadzi case, there is no corruption exception to the Rooker-Feldman doctrine. Regarding claim preclusion, Your Honors, again, only one sentence is devoted to claim preclusion. It's been waived, but even so, the elements of claim preclusion are met here. There were final judgments in both cases now, and although they argue for the first time in reply that the judgments were not final because of standing, this is again waived. It was raised for the first time in reply, and it's wrong. The Illinois Supreme Court in LeBron versus Gottlieb said that Standing does not implicate the court's subject matter jurisdiction. Voidness only results from subject matter or personal jurisdiction. There's an identity of parties and
Thank you,
plaintiffs.
counsel.
Thank you, Your Honors.
Ms. Hanson.
May it please the Court, Assistant Attorney General Christina Hansen for State Defendant Appellee, the Honorable Joel Shupak. Judge Shupak joins in co-appellee's arguments that the District Court correctly dismissed plaintiff's claims for lack of subject matter jurisdiction because they are barred by the Rooker-Feldman Doctrine. But should this Court find that it has jurisdiction over plaintiff's claims, the dismissal with prejudice of the claims against the judge was proper. As the District Court concluded, absolute judicial immunity unquestionably applies to plaintiff's claims. First, Judge Shupak did not act outside of his jurisdiction. As the presiding judge over the 2 foreclosure cases, there's no dispute that he had subject matter jurisdiction over the cases. And second, all of his alleged conduct was taken in his judicial capacity. The allegations in the complaint pertaining to the judge were that he engaged in ex parte communications and violated COVID-related general administrative orders. But those allegations relate to the motions, the hearing of motions, and rendering decisions on those motions before the judge, as well as the related acts of scheduling those motions and giving notice of those motions. And those are part and parcel of the judge's judicial acts of deciding cases.
Counsel, should we care that the district court did not provide the plaintiffs an opportunity to respond to the motion dismiss?
This court has held that it's error that the district court did not allow plaintiffs a chance to respond. However, it's harmless error because under this court's decision in the Kowalski case, it's harmless error because plaintiff was able to put forth their arguments in the district court. There was a subsequent motion, a motion to vacate, and with their motion, they submitted their scheduled filing, which was the responsive pleading to the motion, to Judge Shupak's motion to dismiss. And so all the plaintiff's arguments were before the court when the district court ruled on the motion to vacate. But also, plaintiff's arguments are in the record, and since this court conducts a de novo review, there's a full record on which this court can make its determination, and so any error would be harmless. So for those reasons, we ask that you affirm.
Thank you very much, counsel. Ms. Reback, anything further?
Yes, thank
In my brief time, I'll just say the following. Dicta cannot extirpate Exxon. Exxon makes the standard that Illinois has engrafted this effectively final, and courts have willy-nilly repeated it without looking at the underlying cases is not correct, and it's not right, and the Supreme Court would never condone that. The second point I want to make is, just as the court has said, HSBC Townsend in the colloquial gets it. It understands what is required under Illinois law, which is the governing law, for a foreclosure judgment to become final.
HSBC Bank is about federal principles of finality.
It is.
And if you are relying entirely on state principles of finality, then HSBC Bank is irrelevant.
Except that HSBC Bank reiterates what finality is under Illinois law.
No, it does not discuss, it does not turn on Illinois law. It is about finality for the purpose of 28 U.S.C. 1291. Really, that's what it's about.
Okay, very well, Your Honor. I still respectfully submit that under Illinois law, you cannot appeal a foreclosure judgment which has not been the subject of an order confirming a sale, and then only do you have jurisdiction in the Illinois Appellate Court. Two other points before my time expires, and that is, I come back to, I do believe that HSBC versus Townsend is expostulatory in terms of recognizing the law, and the court is correct. And I do not think we sandbagged in any way the district court by not making the argument that you have to have confirmation of sale. Rooker-Feldman did not bar this case, and in any event, I do believe we made that point. The last point I want to make is counsel said...
Thank you, counsel.
Thank you.
The case is taken under advisement, and the court will be in recess.
Thank you.